The Supreme Court delved once again into a high-stakes, long-running political debate today. What is and is not allowed when lawmakers draw electoral districts? Jeffrey Brown explores the legal dividing lines.
In October, the court heard a case from Wisconsin arguing the state's political map had been unconstitutionally redrawn to favor Republicans. Today, another case, another state, with a claim that a Maryland district was redrawn to help Democrats. As always, Marcia Coyle, chief Washington correspondent for the National Law Journal, was in the courtroom for the arguments. Welcome back first.
Thanks, Jeff.
And first, this term, extreme partisan gerrymandering. We know politics is always involved in this,
Absolutely.
but it's a question of how far you can go.
That's right. That's the exact question. And also, how do you measure it? What kind of a test or standard do you use to root it out?
So tell us about the Maryland case.
Back in 2013, a group of Republican voters filed a lawsuit claiming that the Democratic Maryland General Assembly had engaged in a partisan gerrymander when it redrew the district lines for the 6th congressional district. The General Assembly had basically flipped it from a safe Republican district to a Democratic district. These voters claimed that that was a violation of their First Amendment rights because they were singled out and retaliated against because of their voting views. A lower federal court would not issue an injunction, temporary injunction, blocking that map of the 6th district, and the voters brought that case to the Supreme Court.
And as I said, the court had heard this earlier case in Wisconsin. The legal argument in Maryland was the First Amendment, different from Wisconsin.
Right. In the Wisconsin case, the challengers who did win after a trial had based their claim on the Equal Protection Clause. They said that the state legislature had cracked and packed Democratic votes in order to dilute their effectiveness. That was a violation of equal protection of law.
Okay, so what did you hear today in the court?
Well, basically, I think there were three things. Almost immediately off the bat, Justice Ginsburg and Justice Kennedy wondered, is it too late to be dealing with this because of the November midterm elections? If anything the court decided in favor of these voters, was there time enough for the lower court to see that a new map could be adopted?
So because they don't want to decide things that are moot.
That's right. And Justice Kennedy pointed out that if they did that, wouldn't the court be upsetting settled expectations, disrupting the election process? So that was obviously very much on their minds and might portend a narrow ruling if enough justices feel strongly that they don't want to go down that road. The bulk of the arguments really focused on the legal theory here, the First Amendment. Jeff, as you know, in 2004, the court kind of threw up its hands about partisan gerrymandering, saying we can't come up with a test, a standard that lower courts can use.
It's interesting. It's one of these things that's been around forever, but the court has never been able to decide, never decided it.
Right, exactly.
Yeah.
And when the court took the Wisconsin and the Maryland case, it sort of indicated they were willing to try again to find that test. Is it the First Amendment? Justice Alito was skeptical. He said that he felt that under that legal theory, a legislature would never be able to redistrict. If there was just a trifle bit of partisanship, there could be a constitutional violation. Justice Kennedy seemed a little more open to it. In fact, he said he felt that this might be the kind of case where the First Amendment does fit. So you came away thinking, well, here we go again. They seem decided unsure as to whether the First Amendment is the right test.
And the political implications are potentially major.
Absolutely. Whatever the court decides, especially if it finds a test, could revamp how districts are drawn across the country. And it's also, very important for your right to vote. I mean, if you live in a district that has been rejiggered, its lines are rejiggered so that the outcome is foreordained, are you going to vote? Do you feel your vote has any value? And I think that's the other big consideration here as to why the justices are looking at this.
They're very aware of the potential implications.
They are, as well as the possibility that they could be opening the door to many partisan gerrymandering lawsuits.
All right, Marcia Coyle, as always, the National Law Journal, thank you very much.
My pleasure, Jeff.